Thank you to everyone joining us both in person and our virtual audience from around the world. We are streaming live to our international audience from 12 Bloomsbury Square in London. My name is Catherine Dixon, and I'm the Chief Executive Officer of the Chartered Institute of Arbitrators, FCIArb. Before I introduce Claudia, a few housekeeping notes. For in-person attendees, in case of a fire alarm, please follow the staff instructions and evacuate the building. The meeting point is opposite to the main entrance at Bloomsbury Square Gardens. For our virtual audience, you can explore the virtual platform using the navigator bar on the top. During the session, use the chat function on the right-hand side of your screen. Please try using the chat now. Maybe tell us where you're joining us from. If you're struggling with anything, please use the help widget located at the bottom of your screen, or let us know in the chat and we will help you. You can use the Q&A function to ask the speaker questions. We'll be taking virtual and in-person questions at the end of the lecture, so please get your questions ready. The lecture is being recorded and will be available on our virtual platform and on FCIArb's YouTube channel immediately after the lecture. If you want to ask a question in person, please keep in mind that you will be recorded. So if you'd prefer not to be recorded, you can ask your question on the virtual platform. I'm also delighted to announce that we'll be hosting a global conference in Doha, Qatar next year in October. So please get the date in your diary. October the 30th. Save the date. The global conference, which is open to members and non-members, will feature a range of distinguished speakers, connect the ADR global community, and explore hot topics in dispute resolution in talks, seminars, and networking opportunities. Bookings will be open early in the new year. If you would like to be notified when the registrations are open, please fill out an expression of interest form that is in the chat, or follow us on LinkedIn. Also, our education and training courses set the recognised global standards for practice in ADR, and it's really important, it's absolutely critical for us that we remain relevant and that FCIArb practitioners are involved as we develop our courses in a changing world. We will therefore shortly be launching a stakeholder engagement exercise about how we assess against our agreed competencies. If you would like to get involved, please email us at reformed, which sounds slightly, reformed@fciarb.org. And look out for details on our news web and our pages tomorrow. We're keen to hear from a range of views, including from those practitioners that are for underrepresented groups, in line with our commitment to equity, diversity, and inclusion. I'm very excited about Claudia's lecture today and to hearing her views on the different approaches used by arbitral institutions and how this can impact on the arbitral process. And of course, the role of arbitral institutions can play in preventing and resolving disputes and meet the changing needs and expectations of practitioners in the global business community. Is it true that arbitration is only as good as the arbitral institution? Claudia will share her views. I'm also joined here tonight by Jonathan Wood, the President of FCIArb. Jonathan will be moderating the Q&A discussion after the lecture. Jonathan is an independent arbitrator with over 40 years' experience in the field. He was elected as FCIArb's president in 2022, having served as the chair of the Board of Trustees for 5 years. Jonathan is the director of the London Chamber of Arbitration and Mediation and the chair of International Arbitration at Reynolds Porter Chamberlain RPC. He's also a founding member of Legal UK and the Virtual Arbitrations Forum. I would now like to welcome our speaker, Claudia Salomon FCIArb. Claudia became the president of the International Court of Arbitration, the ICC, in July 2021, and is the first woman in the role for its 100 years history, which is a massive achievement, so congratulations, Claudia. Claudia is widely recognised as one of the leading arbitration practitioners of her generation, with now more than 25 years' experience representing parties in some of the most complex, high-value and significant disputes. Claudia is also an independent arbitrator specialising in international investor state and complex commercial issues. Claudia is a member of the New York Bar, a solicitor in England and Wales. Claudia graduated from Harvard Law School, cum laude, and Brandeis University, sum cum laude, with honours. She's also studied at Somerville College and Oxford University. Welcome and thank you, Claudia.
Thank you. Great. Spain was just hit with horrific floods. A ferocious cyclone struck the Philippines and other Asian countries. And a few weeks ago, Hurricane Helene made landfall on the Florida Gulf Coast and made its way north to devastate parts of North Carolina. Then, just as Floridians were picking up the pieces from Helene, Hurricane Milton hit. These storms caused immeasurable loss. And as the survivors and the homeowners made insurance claims, many of them were surprised to find out that they were not covered. In some areas where Hurricane Helene hit the hardest, less than 1% of homes had flood insurance. Industry experts say that many homeowners simply didn't know that their standard home insurance doesn't cover floods. Now, you might be wondering why I'm talking about insurance and the disturbing weather events of 2024 instead of arbitration, given that I am not a meteorologist. Well, the answer is the same one I give to in-house counsel all over the world. A dispute resolution process is a lot like buying insurance. Insurance is something we must have, but hope we never need. If there's a disaster, you don't want to be caught out like the residents of Florida and North Carolina, because they thought they would be reimbursed for their losses they suffered, but will probably receive nothing. Seen through the lens of the dispute resolution process, a company might think it has an avenue of recourse, only to find out that it doesn't, or believe it has a process that is fair and impartial, only to find out that it doesn't. Dispute resolution clauses are often called the midnight clause or the 11th hour clause. All too often, they're negotiated at the end of a contract, many times after midnight, as more or less an afterthought, with very little consideration given to the consequences. And from my experience, raising the issue when the parties are tired and emotional, well, it can seem unseemly. It's a little like presenting a prenuptial agreement when you propose marriage. I will love you forever, but just in case it doesn't work out, please sign here. Now, when disaster strikes, we want an insurance company to settle the claim quickly and fairly and pay what it is owed to policyholders. No one wants to buy insurance from a fly-by-night company only to find out that it can't pay the claim because it's gone bankrupt. Customer service also matters. And it's the same with alternative dispute resolution. Companies need a process that they can trust so they can get back to business. Now, it is a truism, as Catherine said, that arbitration is only as good as the arbitrator. Does it also hold true that arbitration is only as good as the arbitral institution? Over the past few decades, there has been a proliferation of arbitral institutions on a global, regional, and local level. Some offer specialized services for disputes arising in a particular trade or industry, and others offer arbitration for all types of disputes. Many are funded and often closely linked to their local or national governments. Now, China alone is now estimated to have more than 200 arbitral institutions, and there are nearly 100 in Africa. But as the number of such institutions grows, we have to ask whether they are providing the parties with the best services and meeting the expectations of the parties. So to answer that, we must first determine what role arbitral institutions should play when parties entrust them with resolving these disputes. Can anyone just get some fancy office space, maybe a hearing room or two, adopt some rules, and promote their arbitration services? Is an arbitral institution a mere administrator? Or should an arbitral institution have a greater purpose in protecting the integrity of the arbitral process, promoting the rule of law, and providing access to justice? If an arbitral institution is a guardian, it would protect and defend the integrity of the arbitration process and ensure it doesn't get derailed. If an arbitral institution is a gatekeeper, it would control access and decide who may participate in the process. And if it's a guide, it would help the parties find their way. So to put all of this in context and determine the role arbitral institutions should play, let's first consider the many ways there are to resolve a dispute. So, unfortunately, violence and all-out war are still common methods of dealing with conflicts. The duel has thankfully fallen out of fashion, but it was for centuries a legally sanctioned method for resolving disputes in many parts of the world. At the time, there was little trust in the courts, and there was widespread perjury. So dueling became a popular alternative for obtaining justice, and many believed it truly decided guilt or innocence. And long after dueling was made illegal, duels were still considered to be a faster way of settling disputes than going to court when the issues involved unpaid debts, insults, or honor. And this is what sparked the most famous duel in American history between the Secretary of the Treasury, Alexander Hamilton, and Vice President Aaron Burr in 1804. Well, sadly, Hamilton died, but the tragedy did lead to the creation of one of the most entertaining and successful Broadway shows ever. Now, there are more peaceful alternatives to resolving disputes. Does anyone have a coin? Well, to speed things up, I have one here. So, tails. A coin toss is a quick and easy way to decide which team gets the ball or which end of the field a team will play. But who is willing to have their $100 million gas pricing dispute or their $100,000 contract claim resolved by chance? Such a random approach to decision-making is not something most people would find acceptable. When commercial contracts are involved, and I'm only going to speak tonight about commercial disputes and not investment treaty disputes or consumer disputes, there are generally two ways to resolve a dispute peacefully. The first is, of course, national courts, and the second is arbitration, the out-of-court resolution of a disagreement between parties decided by an impartial third party. In short, it can be called private justice. So I'm going to ask the audience here live to tell me, to shout out, what are the main reasons parties choose arbitration? Anyone? Flexibility? Confidentiality? Neutrality?
Distrust of national courts.
Distrust of national courts? Expertise? Enforceability of the awards. I think we have hit the primary ones. Parties choose whether it's a domestic dispute when all the parties are from the same country, or an international arbitration when the parties are from different countries. Parties want decision makers with specialized knowledge, a neutral process that does not take place in the courts of either country, flexibility to tailor the process, confidentiality, and in cross-border disputes, the number one reason parties choose arbitration is because they want an enforceable award. Now, after opting for arbitration, parties must then choose between ad hoc arbitration or institutional arbitration. And the central role of institutional arbitration is recognized in Article 2A of the UNCITRAL Model Law, which defines the word arbitration as any arbitration, whether or not administered by a permanent arbitral institution. The model law also recognizes that where the law leaves the parties free to determine a certain issue, such freedom includes the right of the parties to authorize a third party, including an arbitral institution, to make that determination. Ad hoc arbitration has been around since arbitration itself, and it does remain the norm in places like Canada, Australia, and India, along with the growing acceptance in China. Institutional arbitration is part of the modern history of arbitration, which is linked to the creation of the ICC International Court of Arbitration in 1923. So this leads to an important question of how to define an arbitral institution and its role in dispute resolution. As Remy Gourmet has noted in his excellent book on the function of arbitral institutions, and I do recommend that, one approach is to think about institutional arbitration in contrast to ad hoc arbitration. So in ad hoc arbitration, only the tribunal and the parties to the disputes are the participants, and they are responsible for organizing the process. Institutional arbitration adds an additional participant, the institution, and takes on a number of tasks. Building on that distinction, Klaus Berger and other authors have written that institutional arbitration has three defining features: arbitral proceedings conducted under pre-formulated arbitration rules, the existence of a permanent body, the institution, which has issued those rules, and the administration of the arbitration by the institution as a contractual duty arising out of a service contract concluded with the parties. This definition, however, doesn't capture the fact that there's a variety of hybrid approaches like the LMAA and the FOS-FA. Other variations are the United Nations Compensation Commission, the Iran-US Claims Tribunal, which are established after specific events and are not functioning on a permanent basis. This definition of institutional arbitration also doesn't capture the fact that the way institutions operate varies greatly. And as a result, an arbitration conducted under the rules of one institution may differ quite significantly from another. How an arbitral institution operates, who makes the decisions, and the services it provides can have far-reaching implications for the integrity of the process, how it is conducted, and most importantly, the enforceability of the award. Charts comparing the various rules of different institutions do not reflect their true distinctions. So now I want to ask or talk about the role of an arbitral institution and ask if it should be guardian, gatekeeper, or guide. So let's start with a guardian, defined as someone who protects or defends something. Guardian might conjure up images of the Marvel movies, Guardians of the Galaxy, a group of intergalactic criminals who must pull together to save the universe. And while institutional arbitration isn't necessarily going to save the world, I do think of an arbitral institution as a guardian of the arbitration process. Institutional arbitration protects the process from getting derailed. Ad hoc arbitration depends on the cooperation between the parties and their lawyers, backed by a well-functioning legal system in the place of arbitration. For instance, in an ad hoc arbitration, it's easy for the responding party to delay the arbitral proceedings by simply refusing to appoint an arbitrator. This means at the very outset of the proceedings, there will be no arbitral institution in place and no book of rules available to deal with the situation. And even when the respondent collaborates or cooperates, the parties may face some genuine disagreements that will need to be resolved. If the tribunal already exists, this requires a decision by the arbitral tribunal or application of a party. Prior to the constitution of the tribunal, it means an ad hoc arbitration seeking a decision from the domestic courts. Resorting to the tribunal of the domestic courts or deciding every procedural agreement is obviously time-consuming and costly. In sharp contrast, the rules of arbitration institutions offers a more efficient procedural safety net. Now, all of the advantages of institutional arbitration can be achieved by making appropriate contractual provisions at the time of making the arbitration agreement. But it's rare for an ad hoc arbitration to provide as much detail as the rules of procedure offered by institutions. And this is probably because doing so would just be impractical, disproportionately cumbersome, and costly. But even for detailed ad hoc arbitration agreements, their wordings may seem ambiguous or worse, inconsistent, unlikely to be found in institutional rules. At least institutional rules have been tried and tested over time. Well, some of them. The ICC rules were first enacted in 1923 and then have been amended over the past 100 plus years. And with each revision, the ICC sought to bring more clarity based on the knowledge and experience of the institution over thousands of cases. So guardians are there to protect us. But what elements of the arbitration process actually require protection, right? For one, if there's a lack of clarity regarding what dispute should be in the arbitration, or a lack of clarity about the process itself, parties can spend years in court fighting before the arbitration even begins. If one party doesn't appoint an arbitrator, or they can't reach agreement on the appointment, and the court date is approaching, that process alone can take more than a year, something we've seen in India. What's more, the arbitral institution is also there to address situations in which the parties have not included key information in their dispute resolution clause, such as the number of arbitrators, the place of arbitration, the language of arbitration. All of those decisions can have significant impact on the arbitration if, for example, there are no rules in place, there's no agreed mechanism to address those situations, or if the parties simply don't agree. These issues can be resolved in a matter of days with a good arbitral institution, or years without guardians protecting the integrity of the process. As guardians of the arbitral process, one of the key roles of the arbitral institution is the appointment of arbitrators if the parties don't nominate them. Another function is ensuring the independence and impartiality of the arbitrators through the appointment, challenge, and removal process. So I'll ask you, how interventionist should the institution be beyond considering independence and impartiality? Should the institution consider any other factors? So at the ICC Court, 75% of the arbitrators are either nominated by the parties or by the co-arbitrators when selecting the president of the tribunal. During the confirmation process, arbitrators are asked to provide information about their availability. So let me ask you, raise your hand, would any of you agree that the ICC Court or any institution should refuse to confirm an arbitrator nominated by a party who appears to have 50+ cases and a full calendar for the next 2 years? Anyone think the ICC Court should refuse the party's choice? I do see a few hands here. Very interesting. What if the arbitrator isn't nominated by only one party, but jointly nominated by the parties as a sole arbitrator or president of the tribunal? Should the institution refuse the appointment? We do have few views. Should an institution override party choice in that situation? We do have some views that that would be the case, or that should happen. But as the head of litigation at one of the largest energy companies told me when we asked that question, absolutely not. They may, in fact, nominate an arbitrator who is extremely busy on purpose. And they would not agree to an arbitral institution overriding their choice in that way. So let me ask you another question. The ICC Court has now administered over 29,000 arbitrations over the past century. What if our experience with an arbitrator who's been nominated by the parties is not positive, and the award in the past has been inadequate and very late? Would you agree that the arbitral institution could override party choice there?
Yes.
We do. Yes. Interesting. From the perspective of the in-house counsel, absolutely not, according to what I have heard from them in many countries. The choice made by the party is valued by those who have expressed their views to me, and they do not want the institution to quash that decision, even if we actually know better. So from their perspective, and it may be very different from the perspective in this room of people who are primarily serving as arbitrators, the role of the guardian protector has limits. What if the arbitral agreement itself is unconscionable? If an arbitration agreement grants one party the right, for example, to nominate the sole arbitrator or the presiding arbitrator, only one party has that right. Or the arbitral agreement requires multiple claimants or respondents with actually conflicting interests to jointly nominate an arbitrator. Article 12.9 of the ICC rules added in 2021 provides that the ICC Court may appoint each member of the tribunal when the method of constitution in the agreement may pose a risk to the validity of the award. That provision is in line with the well-known decision in Siemens versus Dutco by the French Court de Cassation, and provides an additional safeguard for parties' equality in the constitution of the tribunal. And that is designed to avoid the risk of unequal treatment or unfairness, which may in turn impact the validity of the award. Now, at the time of the adoption a few years ago, it was expected that the court would only exercise the power under this new Article 12.9 in exceptional circumstances. And I can tell you that has indeed been the case. Many of those who oppose the approach reject the role of an arbitral institution as a guardian and consider that such issues are better resolved in the enforcement stage. And I beg to differ. Now, arbitral institutions must also ensure the independence and impartiality of arbitrators. In ad hoc arbitration, a party who wishes to challenge an arbitrator must either go to the court or the appointing authority to have the issue decided. Or the objecting party can proceed with the entire arbitration and try to vacate the award on the grounds later. The questions the parties need to ask when selecting an arbitral institution are: what standards does the institution apply when considering challenges to arbitrators? Is there transparency regarding the reasons for these decisions? And fundamentally, who are the guardians of the arbitral process making the decisions? With the proliferation of arbitral institutions funded and controlled by governments, a conflict of interest can arise. We have seen some governments even requiring that disputes be resolved by the local arbitral institution that they are funding and controlling. In this situation, it looks a lot like the fox is guarding the henhouse. Now, at the ICC Court, challenges are decided in special committees, a larger group of court members, rather than three-person committees. And in the special committees, we not only receive an agenda from the ICC Court Secretariat, and we have our counsel for the common law team here in London. They provide a summary of relevant prior decisions of the court, and one court member also prepares a written and oral report, and the issues about admissibility and the merits of the challenge are thoroughly vetted and discussed among the court members who bring their differing legal and cultural perspectives. Reasons for the decisions are also provided if requested before the decision is made. How other arbitral institutions decide challenges varies depending on their structure and approach. For those institutions that have boards or what they call courts with a supervisory role over the case management, they may take the decision. At ICSID, the Secretary General alone makes the decision. At the PCA, what's described as the International Bureau or their secretariat, headed by their Secretary General, makes the decision. Under the ICDR rules, a new International Administrative Review Council makes certain decisions in cases administered by the ICDR, and that includes challenges. According to their website, the council is comprised of a group of current and former high-level AAA ICDR executives who are described as bringing, quote, an extensive amount of ADR and case administration experience to the decision-making process, end quote. The ICDR doesn't identify, though, who is on that council. Under the rules of other arbitral institutions, including one institution headquartered not very far from here, one of my co-arbitrators was challenged in a case I had that I was chairing. And I was surprised to learn that just one former vice president can make decisions about challenges. And they charge an hourly rate to do so. So the broader topic of disclosure and the standard for deciding challenges goes beyond this lecture. What is clear is that the expectations of the parties regarding what arbitral institutions should do to ensure the integrity of the arbitral process as guardians of the process is definitely evolving. One general counsel of a major international company strongly expressed to me his view that deciding to accept a challenge is not sufficient. If an arbitrator is successfully challenged, for example, during the arbitration, and a partial award has already been issued, it calls into the question the partial award which have been issued. The general counsel I spoke to expected arbitral institutions to do much more to prevent the issue from arising in the first place. He wants institutions to ensure independence and impartiality like any sophisticated organization would carry out a robust compliance program. A company doesn't just implement policies and expect employees to comply. There's training involved. Employees must expressly state they're adhering to the program, not just once, but frequently on an annual basis or even more frequently. The general counsel told me that he expected the same process from an arbitral institution, that arbitrators would not simply have an ongoing obligation to disclose, but they would be expected to frequently and affirmatively state that they have nothing to disclose. So as the ICC Court goes through its rules revision process with the expectation of publishing new rules at the start of 2026, this is definitely the kind of direct feedback we will take to heart. As guardians of the process, arbitral institutions must also be concerned with determinations regarding consolidation of two or more arbitrations. And the question remains, who are the guardians of this important issue? Who decides whether two or more cases should be consolidated? Most institutional rules provide that the institution decides, although SIAC and LCIA have variations on that approach, with the tribunals having a role in certain circumstances. The outlier is ICDR, which provides that this International Administrative Review Council, whose membership we don't know, appoints a consolidation arbitrator to make the decision if the parties don't agree upon a procedure for the appointment of the consolidation arbitrator. And when the consolidation arbitrator makes the decision, they don't have institutional guidance and are not provided with any specific background regarding the approach. And I've heard this from those who have served as consolidation arbitrators. Instead, they are charged with making the decision, and they also charge an hourly rate to do so. Now, maybe you've noticed that I've been mentioning fees a lot. And that's because I want to debunk a pervasive myth about institutional arbitration. I frequently hear, as many of you will, that parties use ad hoc arbitration because they think institutional arbitration is too expensive. It is true that with institutional arbitration, the parties have to pay the institution as well as the arbitrators. But in ICC arbitration, a study shows that the institutional fees are typically less than 2% of the total costs of the arbitration. About 85% of the costs are the lawyers. 14% or so are the arbitrators. So I want to ask all of you a question. It's a question I put to audiences I address all over the world. Raise your hand if you are working in a law firm or have worked in a law firm. Raise your hand. If you've ever worked in a law firm, virtually, you can raise your virtual hand too. Keep your hands up, 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 up. Now, keep your hands up. How many of you have ever marketed yourself as the cheapest lawyer? As I suspected, none of you. And is the lawyer with the cheapest hourly rate always the least expensive lawyer? Of course not. When I worked at a law firm, clients would often invite a handful of rivals to the final round of a pitch, and they would say, all of you are qualified. So tell me, why should we work with you? You are selling yourselves. You're selling your services as a trusted advisor, not the cheapest lawyer. And the services that you're selling should provide value to the client. And so it is nonsensical. It's nonsensical for lawyers to be advising their clients to pick the cheapest arbitral institution. It's also wrong to conclude that ad hoc arbitration is necessarily cheaper because the parties don't have to pay the institution. The question everybody has to ask is this: are you getting value for those fees? And is the service that the institution provides allowing the party to avoid or minimize time and costs that would otherwise arise in another process? In ad hoc arbitrations, the absence of such services can result in prolonged delays and substantial legal costs. So from this perspective, the administrative fee is far from expensive because it helps the parties avoid delays and legal costs. Institutional arbitration can also offer a crucial advantage in relation to the arbitrator's fees as well as other costs. In ad hoc arbitration, arbitrators' fees are decided by negotiation between the parties and the arbitrators, and this can be awkward and unfair to the parties. And the arbitrators also have to determine ways to administer those expenses unless they allow an institution to handle those issues. So that means the parties are paying for the administration of the fees or the arbitrator's additional time managing those issues. In an ad valorem system, in institutional arbitration, there's also more certainty and predictability around the cost of an arbitration. And with an ad valorem system, there's no risk of an arbitrator padding their hours to get increased fees. In India, for example, we know that arbitrators in ad hoc arbitration often charge on a per hearing basis. And these hearings can last an hour or a few hours without any limit or incentive to conduct the arbitration in an efficient manner, thus escalating costs. Now, another way in which arbitral institutions guard the integrity of the process is through monitoring the proceedings. This ensures the case is proceeding as expeditiously as possible and that due process is followed. Many institutions say they exercise a degree of monitoring, but the extent to such monitoring varies greatly from one institution to another. As Remy Grimet wrote, the supervision is arguably the area where the sharpest differences can be seen in terms of the degree of interference of the institutions with the proceedings. Now, as guardians of the process, what role should the arbitral institution have if the arbitrators don't perform the way they should? One of the reasons parties sometimes say they're hesitant to use arbitration is because it's final and binding without any right of appeal. In an ad hoc arbitration, the arbitral institution doesn't play any role, and that's the case in most institutional arbitrations. And if there's any review, it's not much more than proofreading, if that. I know most of you are familiar with the ICC's process of scrutiny, and it's unique in the arbitration world and an essential feature of ICC arbitration. No award, whether partial, final, or even by consent, may be rendered by the tribunal without first being scrutinized and approved by the court. The point of scrutiny is to make the award as enforceable as possible. We don't approve awards in about 10% of the cases. And that makes me think, what would happen in those cases if the arbitration had not been under the ICC rules? In those cases, the only avenue of recourse for the losing party would be to have the award vacated. And this underlines the very reason parties choose arbitration in the first place, to get an enforceable award. What happens if there are requirements of mandatory law at the place of arbitration applicable to the proceedings, such as the various requirements regarding the deposit of an award? What if additional information may be required to be included in the award to show that specific aspects of the proceedings have been conducted in an appropriate way. Most institutions do not provide any assistance regarding these mandatory requirements. The parties and the arbitrators must know these requirements, or the enforcement of the award may be at risk. As guardians of the arbitral process, the ICC Court is unique in offering this service. Now, as a final point on the role of an arbitral institution as guardian, I do want to touch on corruption. After the lengthy decision that overturned an $11 billion arbitral award against Nigeria, Mr. Justice Knowles raised an important call to action for the arbitral community. And I'm just going to quote one of the last sentences in his award. "The circumstances of this case, which are remarkable, provide an opportunity to consider whether the arbitral process, which is of outstanding importance and value to the world, needs further attention where the value involved is so large and where a state is involved." Now, before this decision, the ICC Commission on Arbitration and ADR had established a task force on corruption. And the extensive analysis done by the task force on red flags or other indicators of corruption in international arbitration, including the role and responsibilities of the tribunal related to red flags, will be published shortly, with the full report to be released next year. And I think one of the chairs of the task force is here this evening. So what role should arbitral institutions play in this regard? Anecdotally, we hear of an increase in the use of ad hoc arbitration in certain parts of the world where arbitration is used for money laundering. The tribunals use a sham award based on fraudulent contracts and then transfer funds legally, in quotes. Now, as far as the ICC Court is concerned, the close monitoring of cases from start to finish helps to forestall the effects of such schemes and affords protection against corruption, bribery, and money laundering. And this is also one of the key considerations for the ICC Court during the scrutiny process of awards, including consent awards. A red flag might include a contract price for goods and services that far exceeds the usual market price, or a settlement amount that is not grounded in the value of the contract. And when those issues arise, the court will provide comments to the tribunal asking whether those issues have been examined, and if not, whether the proceedings need to be reopened to consider them. The comments from Mr. Justice Knowles will no doubt provoke debate about additional safeguards that should be in place to prevent similar abuses and corruption in the future. Now, I next want to discuss the role of arbitral institutions as gatekeeper, and I don't need to go into as much detail. A gatekeeper controls access, whether it's a large crowd at a football match or bouncers deciding who can enter the buzziest club. In most legal systems around the world, judges often act as gatekeepers, particularly when determining whether expert testimony can be admitted into evidence. And in the United States, where I come from, where jury trials are conducted, this gatekeeping function is particularly important. Since the Supreme Court's decision in Daubert, federal judges have been assigned the role of gatekeeper to shield jurors from expert opinions that the judges regard as unreliable. More specifically, a judge may only admit opinions that are based on a reliable method and that reliably apply that method to sufficient facts or data. Arbitral institutions are also gatekeepers, not in terms of admitting evidence, but whether a case can proceed. Under the rules of most arbitral institutions, it's for the tribunal, not the institution, to decide whether there is a binding agreement between the parties to arbitrate the dispute. and that is the principle known as competence. There are some institutions, though, that decide jurisdictional objections or leave the power to decide to the institution on a case-by-case basis. That is such under the CIATAC rules. And when the tribunal decides jurisdictional objections, institutions can have the power to decide on a prima facie basis whether a binding arbitration agreement refers to the relevant rules, subject to review by the tribunal once it's appointed. And this is the case under Article 6.4 of the ICC rules, which establishes a fairly low threshold requiring only that the court be prima facie satisfied that an agreement may rather than does exist. The court needs to be prima facie satisfied that an arbitration agreement may exist. Provided there is evidence pointing to a possible ICC arbitration agreement between the relevant parties, the court will allow the arbitration to proceed. However, a mere allegation relating to the criteria set forth in Article 6.4 is not sufficient. The court will generally require some evidence supporting the allegation, and other institutions take a similar approach. Some rules, like the LCIA and the ICDR, are silent, but we understand would nonetheless refuse to register the case if a request for arbitration is sent to them in a dispute arising out of a contract which either contains no arbitration clause at all or clearly provides for arbitration under the rules of another institution. The reason arbitral institutions would have the authority to make a prima facie decision on jurisdiction is in large part to reduce costs that would otherwise be incurred by having a tribunal appointed only to decide it lacks jurisdiction. As rare as they may be, negative prima facie decisions on jurisdiction have significant consequences. If a claimant faced with the refusal of an institution to administer a case is left with no choice but to commence proceedings in some other forum, which may or may not accept the case, they may have no avenue of recourse. And as Durance and Schwartz put it, if the ICC Court mistakenly refuses to set an arbitration in motion, and there are no courts to which the parties can reliably refer, a party might, as a consequence, be deprived of its only real chance of obtaining effective relief. So this leads me to consider whether the arbitral institution should have a greater gatekeeping function. What happens if a contract includes an arbitration agreement providing for institutional arbitration, but one party argues the contract is a forgery? What if other aspects of the contract are sending up warnings, such as if the payment doesn't reflect the value of the service provided under the contract? Should the institution allow the case to proceed to the tribunal? Or should the institution determine whether it's being used to procure a fraud? But to make a decision about fraud or forgery, the institution would veer directly into the merits of the case, and I submit exceed its role as administrator of the case. The ICC rules state that the court does not itself resolve disputes, but instead administers the resolution of disputes by tribunals. But with the rise of AI and deep fakes, arbitral institutions might have to rethink and expand its gatekeeping role. But institutions also have to remain steadfast in their commitment not to cross the line into the decision-making process. That is rightly reserved for the tribunal. Lastly, I want to talk about guides, and I will be brief. A guide shows you the way. But where are you going? And if the purpose of an arbitral institution is solely to administer the process, a guide is sufficient. And indeed, they should be. At the very start of the pandemic, for example, the ICC Court issued a guidance note on possible measures aimed at mitigating the effects of COVID-19. The ICC Commission has also published numerous guides, most recently on disability inclusion and another on effective conflict management and facilitating settlement. But an arbitral institution is a service provider with an emphasis on service. And if an arbitral institution is going to provide true value, its case management team needs to be accessible, knowledgeable, and responsive to the parties, their counsel, and the arbitrators. And this also includes logistical support. But I think an arbitral institution should have a greater purpose. As Richard Susskind reminds us, when parties have a dispute, they want more than an arbitration. They want a resolution of their dispute. So instead of thinking about arbitral institutions, I should believe we should be focusing on dispute resolution institutions. And in that case, can and should the institution provide guidance to the parties about the dispute resolution process or processes that are best suited for the resolution of their specific dispute? This would facilitate access for the parties to the most appropriate tools at the most appropriate time. And this is something for the future. So this all takes us back to where I started. When the parties choose arbitration, are they going to find themselves without the protection they thought they had, like the homeowners who got caught in the whirlwind of a hurricane without insurance? Or will they have a dispute resolution process that meets their needs and expectations and provides an efficient, client-centric process and an enforceable award? At the start of this lecture, I asked whether an arbitral institution is a guardian, gatekeeper, or guide. I submit to you this evening that arbitral institutions must act as guardians, gatekeepers, and guides. Thank you very much. Thank you.
Well, thank you very much, Claudia. And I want to congratulate you on 2 counts. Firstly, for an extremely interesting and thought-provoking lecture. So thank you very much. And secondly, on your reappointment for a second term for 3 years as president of the ICC. So congratulations are due.
Thank you. Thank you.
A worthy appointment indeed.
Thank you.
So, international arbitration is replete with acronyms. We have what I call the 4 A's of efficiency, expedition, enforceability, and economy. We have the 3 A's of what you might call availability, accountability, and also affordability. We now have the 3 G's.
Yes.
So why did you choose the 3 G's for this particular lecture?
Yeah. So I travel all over the world and speak with in-house counsel, speak with the parties who are making decisions about whether to use litigation or arbitration, and if they're going to use arbitration, which institution to choose. And so I feel like there are tremendous myths about the dispute resolution process, and really a lack of appreciation and understanding of the risks associated with not having a thought-out dispute resolution policy. I mean, we know that companies that have a proactive approach regarding their dispute resolution approach are better off when a dispute arises and better off with the outcome as well.
Well, thank you. And I think one of the other points about the role of an institution, and historically the ICC have played a huge part in this, as has CIArb, it's in the legitimisation of the process around the world. Some of us think back to the 1970s, the 1980s, when arbitration internationally was not accepted around the world, and we've made fantastic progress in that regard. But you mentioned the proliferation of many institutions now around the world. I mean, you mentioned China with 200 institutions, but it's, it used to be football stadiums, it used to be airports. It now seems that it's arbitration institutions are growing up everywhere. Do you think this proliferation of different institutions in some ways waters down or undermines this idea of legitimisation of the process?
Well, CIArb and ICC do have a shared history over the last 100 years and kind of a very shared purpose in our founding. And in many ways, the growing acceptance of arbitration and seeing many institutions arise can be viewed as a positive. Okay, well, that means the governments are, in theory, pro-arbitration. But what I am concerned about is when the institutions themselves do not have strong reputations of independence and impartiality. It actually undermines the acceptance of arbitration. So I will go to places that will say that we have an institution that is frequently thought of for domestic arbitration, but it doesn't necessarily have the confidence, and so domestic arbitration is not viewed as a strong alternative for companies. And so it does have an impact in that regard. I also think that having an institution, or let's say I will go to different countries around the world and they'll say X number of lawyers in our country are on list of arbitrators, of institutional arbitrator lists. And so we must then have a strong arbitration culture. And I think that's misguided criteria to measure the strength of arbitration in those jurisdictions.
Now, I couldn't agree with you more, because I have an appointing role as president of the Chartered Institute. And many CVs that I see, take note the audience, is a list of institutions to which people belong. But that does not tell me if they're any good.
Or if they have any experience.
Or they have any experience. Yes. So merely being on a list is not very valuable. And I think I agree with you on that count. So yes, a very important point to be made. So I'm now going to turn to the audience. Who would like to raise the first question? I see a hand, inevitably from James Clancy.
Yes.
Thank you very much for your lecture, and thank you for coming to the home of at least two L's as far as London organisations in arbitration are concerned. I wanted to make a point of correction and then a question, if I may. I'm a full-time arbitrator, and I'm a former honorary secretary of the LMAA. And I wanted, first of all, to point out that the LMAA is not hybrid. LMAA arbitrations are purely ad hoc. The honorary secretary of the LMAA cannot do anything at all in an arbitration that is commenced under the LMAA terms. In fact, in London, you didn't mention when you spoke about jurisdictions in which ad hoc arbitration is important. In London, institutional arbitration remains a minority taste. That's a plain fact from the data. I'm afraid in London-seated arbitrations. The ICC has about 3% of international commercial arbitration seated here, and the LCIA has about another 11 or 12, according to last year's figures. So most international commercial arbitrations are non-institutional, whether ad hoc or trade association. And that brings me to my question, which arises from, which is about gatekeeping. So it arises from the fact that the ICC doesn't actually have in its caseload very many cases these days connected with international commerce, by which I mean the buying, selling, and transportation and insurance of goods. It tends more to deal with projects. As a full-time arbitrator, I find it frustrating that what happens is that parties are put off.
What's the question,
yes,
please?
So the question is, why does the ICC and indeed other institutions not have a look at their advances on costs that they demand right at the beginning of an arbitration? Because that acts as a gatekeeper against arbitrators being appointed. The claimants run away when they see those huge advances on costs. Yes, they have certainty about the total cost, but why do they have to pay it up front? Are the institutions, and the ICC in particular, looking at how they might reintroduce parties from international commerce?
So I think you actually have quite a misnomer about ICC arbitration. You wrote about it in the newsletter in a very inaccurate way. So I will state this very clearly. About 40% of ICC cases actually involve amounts in dispute less than 5 million USD. So you're actually wrong that it's only involving projects. Yes, 40% of our cases do involve energy and construction, but we have cases that involve amounts in dispute less than 10,000 USD, with cases up to, many billions or tens of billions of USD. There is many companies tell us they prefer to have the price structure that ICC has. One, to have ad valorem system, because what they tell us is they want predictability. Secondly, if they're more likely to be the respondent, they actually prefer the system where there is an advance on cost. So there's not, it diminishes the likelihood that you have a frivolous claim brought. ICC, and we state this very clearly in our note, has flexibility with regard to installment payments. We also have flexibility if there's other issues with regard to the advance on cost. And the cost structure with an ad valorem system can actually be much less expensive, because when you have small amounts in dispute, you don't have runaway hourly fees. One of the most surprising things that has arisen in my 3+ years now in this role is how many arbitrators call me up complaining about their fees in ICC cases. And one, it's unseemly, but two, it also is telling that if they were complaining, they must have a view that they would be paid more in a different system.
Thank you. So I want to just touch on the point of guide. And the institutions are a service provider, and parties inevitably get on the phone and say, can you tell me how to... Does this put you in, or put the institution at risk in giving some form of advice or guidance, which in turn may backfire because one of the parties might use it as a basis for challenging the award on the one hand, or even perhaps in due course, perhaps suing the institution for some sort of breach of care, a breach of the duty of care. So this role of guidance is quite a high risk area. Yeah. How do we deal with this as an institution?
So there has to be a clear line, and I do believe there is a clear line between legal advice and service. But one of the best lines I heard from one of the counsel in our case management team was saying that when oftentimes people contact the case management team and say, I'm sorry to bother you, but, and the emphasis, the case manager, the counsel of that team was saying is actually, we welcome the phone calls. You're not bothering us. It's actually why we're here. And so the goal is to let people know that the case management teams are different than judges' chambers. You can contact them. So I think those issues of additional risk is really if the institution were crossing into some line of advice and legal advice, and clearly that can't be
It takes
done.
quite a bit of training of the staff in the Secretariat to know how to tread that line.
Exactly,
doesn't it, I
to
think?
walk them through, the process, but not be providing
Yeah,
legal
very
advice.
good. Kristen, do we have any questions online that you'd like to raise?
Sure. Let me see if this is working. It is. Many questions in the chat. So I will start with this one. Does the ICC offer any assistance to tribunals as to some of the risks they may incur in accusing parties of engaging in activities, nefarious activities, such as money laundering?
Interesting. Well, the reports that will be coming out on the ICC Commission task force on corruption, I think, are going to be very valuable. The goal is for that to be a guide for arbitrators and parties related to these issues. The guidance that the ICC Court may provide would be in the context that I described, that if, for example, we have scrutinized an award and identified potential red flags, the question we would raise to the tribunal is, have you considered these issues? Have you raised them? And then it's for the tribunal to assess whether they need to go further. If they have seen or they have identified red flags, they may very well be in touch with the counsel at the Secretariat to discuss, what would be next steps, and then the Secretariat would definitely discuss that with them.
Thank you very much. David, I see you itching there to ask a question.
Well, I've just come from the House of Lords, the third reading of our latest arbitration bill, and perhaps I just give you a bit of information. Corruption was an issue that I raised several times during the process of this bill through our House of Lords, and eventually it was decided that we should wait for the ICC inquiry and what recommendations that the ICC makes. So the ICC is highly influential, certainly on that issue in the House of Lords. I raise one question too, and that is that should arbitration law reform rest with the institutes, or should it rest with the legislation? There's an enormous contrast between the United States of America and our country. I think I'm right in saying that the one statute in the United States is one from 1925.
Yes.
And as far as I know, there have been no further legislation in the United States of America.
Yes.
We, on the other hand, and I was responsible for that, we took the 1979 Act, the 1996 Act, and now the 2024
Yes, yes.
Act. So what is your position on that? And I give you this example from the arbitration bill that is now just leaving the House of Lords, that we put in a special provision to give power to the arbitral tribunal to make summary awards to chuck the claim out or to chuck the defence out. That seems to me something that has to rest with the legislature, and without the legislature, how can arbitral institutes be really effective?
Yeah. You raise a really important point, and I would say one of the kind of important developments over the last 10 years that we have seen, especially in Asia, is the arbitration infrastructure, the legal infrastructure developing very, very rapidly the adoption of whether it's the UNCITRAL model laws or other laws to support arbitration, the adoption or signing on to the New York Convention and other kind of structural aspects that are necessary for arbitration to flourish in and then potentially lead to additional arbitral institutions. So you need the strong arbitral infrastructure, the legal infrastructure. And what we also see is that the statutes themselves in some jurisdictions around the world are not enough, that you can have great statutes, and yet there are still enormous hurdles in the courts for enforcement or interpretations by the courts that are otherwise interfering with the arbitration process. So I do believe that it is essential for the statutory framework to be developed around the world to support arbitration. It will be essential, and I know CIArb is doing great work with judiciary around the world, and that's been part of your long history under many of your predecessors as well, to work with the judiciary, not just in training, but for them to view, hopefully, a view that arbitration is also a positive and not a zero-sum game for the courts. And the institutions, I do believe, can be thought leaders in this regard as well and encourage practitioners and all of the stakeholders to be thinking about standards, approaches, and techniques. And that's something we take very seriously.
Thank you very much. Chikwendu, you have a question. Chikwendu is our African trustee.
Fantastic.
Claudia, thank you very much for sharing with us the benefit of your knowledge and experience this evening. Now, my question is, as I understand it, arbitration runs on the basis of the trust the parties have, both in the integrity of the process and also in the integrity of the arbitrators, which explains why independence and impartiality remains critical, in every arbitral process. Now, my question to you is, what usually is the threshold of the ICC in instances where the arbitrator is challenged? Now, I ask this question with the benefit of my understanding in live situations where arbitrators that are appointed have been challenged and the court overruled the challenge. And the process went on, and then award is rendered. The parties challenged the award in the local court, and it was set aside. So what is your threshold, as a court, in your experience, with regards to challenges to arbitrators? Thank you.
What is the
Threshold.
threshold?
Yes, yeah. Thank you.
There is an obligation that all arbitrators are independent and impartial. That's set out in the rules. So we, in essence, are looking at and taking a two-step approach. One is looking at kind of the timing of a challenge, admissibility, has it been brought within the 30 days? And then do the merits, is the challenge acceptable on the merits? Do we accept it on the merits? There are so many variety of fact patterns that lead to challenges, whether it's the relationship between the arbitrator and the counsel, relationship between the arbitrator and the parties, or other scenarios. So we really have to look at each of these cases on a very fact by and case specific situation. I can say, there is the issue of whether disclosure comes into play, because if a party hasn't disclosed something, our typical approach in that context is that in and of itself is not the basis upon to accept a challenge, the lack of disclosure, but is an additional factor we consider.
So it weighs in the process
Exactly.
and in the decision-making process.
Exactly.
Kristen, do we have any more questions online, please?
We do. So if arbitration centers or institutions move towards proposing or selecting, a suite of options for dispute resolution, does this run the risk of potentially prolonging the entire resolution process?
That is really the balancing issue we hear. For example, one of the techniques that is discussed and encouraged in the ADR report that came out last year from the ICC Commission was encouraging parties to consider settlement windows in their procedural timetables. For example, saying at the very beginning of the case, here are the deadlines for filing your submissions. After the first round of submission, building in a month or two when there is not the rush to get into the next round of submissions or document production, to say, let's see if we can have negotiation or mediation and no party needs to bring it up. As a sign of weakness, it's built into the schedule. Some in-house counsel will say that's a great idea. And other in-house counsel of very sophisticated companies say to me, we don't need somebody to tell us when we should bring up mediation or negotiation or settlement. If we think it should be settled, we're going to bring it up. So there are conflicting views on this. Just like there is, if you have threshold requirements for negotiation and mediation before you can file an arbitration. Some parties view that as too many steps before you can just get on with it. So we sometimes do hear parties and arbitrators and mediators say these things should be required. And we otherwise hear from others to say these should be options, and that's something we have to weigh.
I think this is very interesting because one of the points I was going to raise is should mediation be built into the rules of an institution, for example? And we know that the international AAA, the ICDR, has an opt-out mediation process. And I know that the London Chamber of Arbitration and Mediation has a permissive mediation provision in its actual rules, more as a prompt, but it's aimed primarily at sort of SMEs, if you like, who may not necessarily realise that mediation and arbitration go hand in hand in certain circumstances. But do you think that mediation could be built into the rules, or is it something that we just think about during the process, say at the first procedural hearing? Is there a more dynamic way of introducing mediation into the process?
Yeah. I mean, when we have the printed booklets of the rules, they're printed, can be built in together. But now, of course, everybody's looking at all of this online and looking at, of course, model clauses that have mediation and arbitration together. But the question you raise really of, are there ways in which, as we're thinking about the new rules, there should be potential more integration of options or other ways in which parties are, in essence, guided through these options to affirmatively say they don't want them, is something that we have to look at closely.
Because, what you're dealing with is a very broad church, people who may be very sophisticated, as you refer to your general counsel, who says, well, I don't need anyone to tell me when I go to settlement and negotiations, to the smaller user who probably isn't quite so familiar with the process. And, we all have the med-arb is mediation and arbitration, not necessarily easy bedfellows, but I'm a great believer in mediation, so that's why I raised the question.
And I think one of the things we've really tried to do now is, as we're talking about arbitration or conferences about arbitration, discussions about ADR, mediation, and all kinds of other techniques are worked, are really part of the conversation as opposed to something on the side. Yeah. We understand, as Richard Susskind has emphasized, that parties are looking for resolutions, and I've spoken quite a lot about making sure that parties know what all the tools are in the toolbox.
Black and Decker in Richard's case.
Exactly. It's and so that and we're also really emphasizing that, and this is in the ADR guide and report, both for counsel as well as for the arbitrators, that there's really opportunities to use mediation or settlement techniques once an arbitration has started. And that's one is, of course, thinking about a settlement or a negotiation window, but so many others. We don't always have to be thinking about these ADR techniques before the arbitration arises, but how you may be able to get a settlement with the Damocles sword hanging over you of an impending hearing.
And of course the other issue is, and you referred to the midnight clause, I mean, if you thought about it seriously, you might build it into the draft of the arbitration clause, and that's where, we see escalation clauses, of course, but those are quite often specific to particular industries, such as construction or technology. But drafting mediation into the process of the clause might be another way of dealing with this, because it alerts people to that as a process. Caroline.
Thank you. Caroline Kenny, independent arbitrator. Claudia, thank you so much for your very thought-provoking speech. I wanted to ask you two questions, really. One was about the transparency measures that ICC introduced, such as publication of appointments, and the other one was the adopting the default position to publish awards. I just wondered how have those transparency provisions worked in practice? How have they improved arbitrations for the ICC? And the second question I was going to ask you is that you called out to the audience to identify the benefits of arbitration over litigation, and one of them was confidentiality. Mm-hmm. Yet the ICC to date has not put in or codified confidentiality in its rules, and I was just wondering what the drive behind that is, particularly because in the last 10 years we've seen so many Queen Mary surveys say that confidentiality is so important to users of arbitration.
Yeah. So we have many ways in which there have been additional transparency measures. One is providing reasons for certain decisions, including challenges if parties request. We frequently do get challenges where the parties or one of the parties has not, or none of the parties have made requests for reasons. I do emphasize that providing reasons doesn't delay the decision, that we will communicate the decision with reasons to follow. So I think that has been an important part of or appreciated by parties. I mean, when I was representing or acting as counsel, one of the most frustrating things was to get a one-line email from an arbitral institution that would just say challenge accepted or challenge denied, and you would have no understanding. So I think that has been very important. I wish to emphasize that a publication of awards has in no way diminished the confidentiality of arbitration. There is no inconsistency between confidentiality and the ICC's approach to publication. And why is that? Because we are only publishing awards when the parties expressly consent to publication. And they're actually, they have to consent to the publication of the anonymized award itself. So I won't ask for a show of hands now, but I will just tell you, in many scenarios, when we do ask for the show of hands of to say how many of you would like to have and read more arbitration awards. Everybody raises their hand. And then when we say how many of you would be willing or advise your client to allow the publication of the award, everybody's hands go down. I do believe, and so we do have our, for where the parties have consented to publication, those awards are freely available. It's been slow. There have not been that many where the parties have agreed. So two things. One is awards do get become public when there is an enforcement proceeding, typically because few courts around the world will allow a award to be filed under seal. And so with Jus Mundi and other sources, we know that there's a lot more information about awards. Secondly, I think parties have been hesitant to allow the publication of an anonymized award because they don't have trust that the anonymization process is truly going to be anonymizing. If somebody says a Spanish energy company, everyone's going to know who that is. But if they see over time that the anonymizing process is in fact anonymizing, then they may be more confident in that respect. Mm-hmm. On the issue of confidentiality, it is a question I have been asked in the past. There has been not the default on confidentiality. In some respects, as Jonathan said, because it's a very broad church and lots of different approaches to arbitration, but it is definitely something as we are going through the rules revision that we have to just think about. Should the default be something different than what we have now?
And in the Arbitration Act, of course, confidentiality as a provision was debated hotly, but it was decided not to have a confidentiality provision in the new Act. So it's quite interesting, isn't it? I remember Teddy Landau telling the story about when the 1996 Act was going through. He and Mark Saville discussed this and found that they couldn't come up with the wording, and I think one of the other lords came up and said ridiculous, and they said, well, you come and write it. And they came back and said, you're quite right, we can't find a wording that's suitable. And it's just so difficult to have a wording that suits everybody in a piece of legislation. I don't know about the rules, whether it's more flexible, but it is a difficult question.
And I should emphasize as well, last year, 2023, 16% of the parties were states or state-owned entities. 2022, 25% of the parties were states or state-owned entities. I don't consider that to be a decline. I just consider that to be a year-by-year variation. But the states and SOEs are cases, we only have a few investment treaty claims. Almost all of those cases are commercial cases, construction disputes or supply agreements or other sorts of things. And the states, of course, have many variations on public disclosure. And so an imposition of confidentiality obligations for states is not necessarily something they can sign on to. So it can be a deterrent for states and SOEs to agree to use arbitration or ICC arbitration more generally.
And this is where the driver is to, the public sector and governments are under pressure not to have confidentiality because, we've seen from the PI and D in Nigeria case that, the taxpayer of Nigeria is entitled to see what its government has been up to and such like. So, it raises a very interesting question. Yeah. Any more questions? Do I see any hands up? Or do we have something from online? Or are we?
We do, and maybe this is perhaps a good one to close on. So just a more, reading the tea leaves question, which is, do you see the role of institutions kind of fundamentally changing in the future?
I do. I think technology is going to drive the need for focus on different types of services that institutions will be providing, that we should be thinking about the institutions not just as arbitral institutions, but dispute resolution and dispute prevention institutions. And the entire, if, again, we follow Richard Susskind's way of thinking about technology as not just automation, but transformation, then it is going to transform the way in which parties expect to interact with institutions and the services we provide.
Can I just add, the very title of your talk leads to that.
Thank you.
Well, I think on that note, I would like to thank you, Claudia Salomon,
Thank you.
for a fantastic
Thank
lecture.
you. Thank you. Thank you so much. Thank you.
Thank you. And do we adjourn now, Catherine, for refreshments? Absolutely. Thank you very much. Please join us for refreshments and some networking. Thank you very much indeed.
Great, thank you.
Well done.
Well done, thank you.